In an era when the Patriots Act allows for the search of libraries and the books that you check out, aren't those views about the right to protect your book-buying habits a little bit antiquated in an era of terrorism and other important law enforcement measures?
It's our view that the rights are all that more important now since 9/11. It is what our country is about. It is why we fight to protect our country, because these are the rights that we're protecting. And we feel very strongly that that section of the Patriot Act that allows the federal agents to go into bookstores and libraries and obtain information without public disclosure is unconstitutional, and hopefully it will be challenged, just consistent with this case.
If the crime had been different, would the response of the tattered cover been any different? Would the demands of law enforcement been any different? What if this involved an attempt to catch a terrorist?
The basic principles remain the same. In this case, we did not argue absolute First Amendment protection. One needs to go through the appropriate procedures to make sure that our rights are being protected, and there may be times when information would be turned over.
To be quite honest, this is not my most favorite thing to do, talking about a case I ultimately lost. But I had the privilege of representing the Jefferson County Sheriff's Department defendants in the various lawsuits that were brought by the Columbine victims. And some of those plaintiffs made very vociferous arguments that we should have found out, we should have known, if only we had done this, if only we had done that, we would have prevented them. And I guess there's the tension, because you can't prevent things sometimes because you have to give up rights to do so. And in this case, it's a question of whose rights were paramount, and the Supreme Court has said that the tattered cover's rights were paramount, and we'll live with it.
I like my rights. I like reading books. I like all of the same things that every one of you like. I like my privacy. I like my freedom. And I also see that as law enforcement, we have a job to protect all of those rights for you. And so when we go to get this information, that's what we were seeking. That's why we went and talked with Joyce in her office and asked for the one record. We felt that it was protecting our community to put one person in jail. And if one book record would help do that, we felt that it was that important to every one of you sitting in this room today.
Well, wait a second. No way. They would have kept searching. So to say they only wanted the answer to this one invoice is in fact not true. They would have kept searching because the one invoice didn't give them the answer that they wanted.
I'm going to disagree with that. That is not a true statement, and I think that Dan Reck is going beyond his scope of knowledge here for what I was thinking during that time frame. And when we said we wanted the one and that we were going to complete the search warrant and do a return, I find that a little bit offensive. And so I'm going to make a note of that here.
Joyce, as somebody who has a 14-year-old who wanders around in tattered cover all of the time, I need to ask you, why were you carrying 2 books on how to build meth labs?
We may have been carrying them, or we may not have been carrying them. First of all, we will provide access to any material, however, that is constitutionally protected.
We have never admitted, never, that the books being sought and the information being sought would indicate that this person bought books about methamphetamine. We simply have not disclosed one way or the other. He might have bought a book about poetry in the 17th century. He might have bought a book about gardening, or he might have bought a book about making methamphetamines. And we've never disclosed that. Why? Because we protect your privacy and we protect his privacy. And just like I said to the Supreme Court in the oral argument, I said, you would want the tattered cover to protect your privacy.
I represented the gentleman who was charged in this situation and was sent to prison. And I just wanted to, first off, confirm that he authorized that we could talk about this, correct?
He did do that.
All right. I just wanted, can you confirm what book it was that was mailed in that particular mailer?
Yeah, I can. I must preface my comments by saying we would never disclose that if it wasn't for him or his attorney asking us to do that. And because he, through you, are asking us, I can tell you that the book he purchased from the tattered cover and that came in that invoice had nothing to do with making methamphetamine. The book he purchased was about Japanese calligraphy. That's the truth. The book he purchased, and there was only one in there, was about Japanese calligraphy.
Well, the only thing I can say to that comment is, what do we hear from law enforcement with given that answer?
From the beginning, we never knew what book was in there. And so we actually even said, it doesn't matter to us what the book is because we need to close this piece of evidence. If you're a defense attorney or if you're a prosecuting attorney, every single person sitting in this audience today, like a jury, wanted to know. And we felt that that was a critical piece of evidence. No matter what it turned out to be, we also have a responsibility to gather that evidence. And, you know, when you have the books and you have a mailer, just like the revelation was now, if you were all sitting on a jury panel, did you want to know? And that's what we felt.
May I comment on that? The reason we're fighting about this is we will always fight about this, no matter what kind of book it is. That is the whole point. People have a right to privacy. And whether it's inculpatory or exculpatory, we're not going to give up that information, just like we didn't in this case. Because if we told the police the answer each time if the book happened to be exculpatory, then they would know, you would know, that the times we weren't giving it up, it was inculpatory. So we're never going to give it up. And that's because everybody, all of us, and the people in this room have a right to that privacy.
Well, this is a tough issue, balancing important rights and obligations of law enforcement. But one thing we can say, this is only one decision, and as this discussion shows, this is not the end of the debate. It's really only the beginning. Thanks for coming.